Welcome to the 12th episode of the Financial Incline. I'm your host, John Bovard. Today, I'm thrilled to be joined by Aaron Monk. Aaron is a partner at the downtown Cincinnati law firm of Kohnen Patton. Aaron's work focuses on assisting both privately held and venture-backed companies in a broad range of general corporate issues, including company formation and governance, equity incentive plans, and mergers and acquisitions. Most recently, Aaron helped myself and a couple business partners as we acquired a privately held small business here in Cincinnati, Ohio. On this episode, Aaron and I will be walking through the process of selling your business. So if you're a local business owner and you're wondering the steps and the timeline that's involved, as well as who you need on your team to help prepare you for the process of selling your business, then this episode is for you. I hope you enjoy. Hey, Aaron, how's it going?
Hey, doing well, John. How are you?
I'm doing well. So, like I mentioned in our introduction, so I've known Aaron for a very long time, and he recently helped myself and a couple business partners to acquire a local business here in Cincinnati. So that's one of the reasons why I was thrilled to have Aaron on today, as he can kind of walk us through what it's like and what some of the things that you should consider when you're looking to sell your business. So first and foremost, for any attorneys that may be listening to the call, a quick disclaimer that this presentation is for educational and information purposes only and should not be construed as legal, financial, tax, investment, or any other form of advice. So had to make sure we got that out of the way first and foremost. But Aaron, if you wouldn't mind, can you tell us a little bit about your services and how you help your clients?
Yeah, John. Thank you. And thanks for the disclaimer. My bar license really appreciates it. So basically, I'm a partner at Kohnen Patton. I provide general corporate and transactional legal advisory services, mainly to privately held businesses in the greater Cincinnati region. So I'll act as outside general counsel for a number of businesses, also including primary focuses around mergers and acquisitions, capital markets. So if companies are going to issue stock or debt, to assist in that piece of the legal transaction. Business succession planning, so transitioning the businesses down to either family members or key management personnel, as well as just general corporate law relating to operating agreements, limited liability company agreements, stockholders agreements, and other just day-to-day operational issues with businesses.
Yeah, that's fantastic. And one of the things that I've learned through going through this process, on the buy side of things, is there's a lot that goes into it. There's a lot of readings and a lot of documents, and don't hesitate to get an attorney involved. There's so many little nuances and things that go into finalizing these deals that it's great to have good legal counsel on your side and somebody looking over everything for you. So and to that extent, there's a ton of different steps that go into selling your business. So Aaron, if you wouldn't mind, and for those of you that are watching this, I'm going to go ahead and share kind of a quick timeline of what the transaction timeline is when you are actually looking to go ahead and sell your business. Again, this is for people that are pretty far along. They know they want to sell, and this process can take as long as 36 weeks. Aaron's got this great timeline for us of the kind of the three different buckets of activity. There's obviously a marketing aspect of this. There's evaluation and due diligence, and then negotiations and closing. But if you wouldn't mind, taking a little bit of time just to walk us through, what's the typical timeline? What are the steps to selling your business?
Yeah, John. And really, this is this timeline that's disclosed on the screen is really when you're well aware you've selected an investment banker that's going to represent you in this transaction. They've worked through vetting and getting more information around your businesses, curated prospective lists, things like that. So I really think when someone's interested in selling their company, and we'll get into this a little bit later, this timeline process can take a lot longer than just 36 weeks. But when you're decided to sell, you're ready to go. Typically what kicks this off is basically your investment banker or business broker is going to send out what's called a teaser. And that's just kind of a general overview of your company and some financial information at a high level. There's going to send that out to a curated list of prospective buyers. Once that comes back with people that are interested, then you will have this, or the investment banker will have the prospective buyer sign a non-disclosure agreement, which will give the company protection to disclose the name, who's the selling party, maybe some additional information at that stage. There's also going to be what's called a SIM, or a confidential information memorandum. And that's a very detailed overview of your business and the industry that's involved, the management personnel, financial information, why the company is valuable. I mean, it's a great resource. Investment bankers put a lot of time and effort into that. And really it's a marketing piece that's going to help prospective buyers determine if your business is something that they want to acquire and at what price.
Yeah, great. So do you think someone should, a business owner, should they try to create that SIM themselves?
No, absolutely not. I think it's, I've heard stories of working with clients and that have worked with investment bankers, and they'll say, this is the best piece of marketing advice materials we've ever come up with from our company. I mean, it really, they add a lot of value, that they being investment bankers, when it comes to this. And so, a lot of times business owners, I mean, they are great at what they do in their industry, but this is something completely different. In buying and selling a company is something that investment bankers have a lot of experience in, and they understand what these prospective buyers are looking for. And so it gives them definitely an advantage with curating that information and making it, deliverable to them in pieces they can read. So,
yeah, that's great. So now as we get into the next part, which is, sort of the meat of the process, or the meat of the timeline, will be that valuation and due diligence part. So, this is what seems to be, can kind of take up, the most time. It seems like, the buyers are probably asking you for a lot of information. It might seem a little bit intrusive, pretty time consuming. So if you wouldn't mind kind of touching on some of that process when they're, when you're going through the valuation and due diligence part.
Yeah. So, your investment banker is going to work with you, and they're going to get you up to speed, really, and get a head start on diligence items that a buyer is going to eventually request, financial statements, employee census, who's employed, tax returns, customer lists, revenue numbers, things like that. So that's all going to be uploaded in what's called a virtual data room. And so that's just, what we, share file, Dropbox, things like that people use to organize all the diligence items. There's going to be probably, a handful of management personnel that's going to be talking directly with the buyer group to ask questions, to, further vet the company, and to validate, valuation, as well as growth opportunities there. Further meetings take place, and after the initial diligence item to come up with the valuation of the company, what's going to happen is the buyer is going to present what's called a letter of intent to the seller. And that's going to outline, not only the purchase price, but, the structure of the acquisition, whether it's going to be an asset sale or a stock sale, how the purchase price is going to get paid. Is it going to be all cash? Is there going to be some form of equity part as the consideration? Is there going to be a seller note? earnouts, things like that. So it gets into detail there, as well as maybe some other items related to restrictive covenants like non-competes, post-closing, confidentiality, things like that. So, so that's definitely something that takes a lot of time. And really, when it comes to my role as an attorney, typically this is all done prior. We'll be engaged, but we won't nearly have the level of involvement that your investment banker is going to have at this stage in your accounting team to put together like financial, the documentation that the buyers are going to request.
Right.
But it's extremely important, as we'll get into later.
Yeah. So it looks like there's certain stages there, like you have the expression of interest, or what some might call an indication of interest. That's something that you sign. From what you said, it's non-binding. So what then happens with the LOI? Would the LOI is that binding? Is that also, are there ways to get out of the LOI as well?
Yeah.
It's pretty.
That's a good.
Seems like it's pretty far along in the process. And kind of going through the due diligence period. When could, if somebody looking to sell, when could they really say, okay, this might not be the right group we're going to sell to. I'm going to pull the plug.
Yeah, I mean, so as a general rule, like a letter of intent is non-binding. Now there's going to be, and it's going to say it, multiple times throughout the document that this is a non-binding letter of intent, except for a handful of provisions related to confidentiality. So information that's being disclosed between the parties, is supposed to be kept confidential and only given to, attorneys or financial advisors or on a need to know basis with the buyer or seller group.
Yep.
As well as an exclusivity clause that's typically included in a letter of intent. And what that clause basically means is, prior to, buyer putting in more time and more resources and efforts and costs, they want to make sure that you are not continuing to solicit offers for this business. They want to, at this stage, they want to make sure that, you signed a deal with us. We're negotiating one-on-one. This isn't something that you're going to go take our letter of intent and then go turn around and try to get, an extra 10% of a purchase price or use us as a stalking horse, so to speak. So that's going to be a binding provision as well. Sometimes there's some other binding provisions in there, but for the most part, confidentiality, exclusivity, fees, who pays what, things like that. And typically at this stage, it's each party pays their own expenses. Yep.
Okay. All right, great. So really, up until that LOI is signed, it seems like the seller holds most of the power, right? I mean, they kind of have the decision, they can get in and out, but then once that LOI is signed, and that exclusivity is granted, that sounds like a big step, right? I mean, that sounds like you better be pretty sure that this group is the one, because if you select them, give them an exclusivity period, you probably wouldn't want to go back to those other people once the exclusivity period's up if something did fall through. It really sounds like you want to have your ducks in a row once that LOI is signed.
Oh, absolutely. And that's why I always advise clients to early on get the attorneys and your advisory team involved at this stage. Yeah. Because you're right, leverage is going to shift once that letter of intent is signed. Right now, you have multiple options. You can bid that out and really use the multiple buyers to leverage against each other to get more favorable terms. Once that is done and you're under exclusivity, you can't then go back to those other prospective buyers and say, well, hold on, I think we may have a deal here. That time period is ended. So you want to make sure. And that's why I always, especially when I'm representing clients on the sell side, want to be as detailed as possible in the letter of intent to any points of contention that we know are going to arise down down the road at the definitive agreement purchase stage, we want to resolve those now because we have the leverage to do so. So that's a great time to get a lawyer involved. I think sometimes people just think of this as it's a non-binding agreement. We agreed on the price, but there's so much more to a deal than just the purchase price, and it's important to use your leverage when you can to negotiate those points.
Yep. All right. Well, great. So, I thought that part of the process, like I said, from the buying side, I thought that took a pretty long time. As you can see, it's kind of the chunk of the timeline, but the negotiations and closing, this is when you might run, what do they call it? Deal fatigue. If things are starting to drag on a little bit, if the timeline's accurate, you might be, 25 to 30 weeks into this process when you're getting into the negotiations and the closing. I could see your 3 bullet points there of the quality of earnings report, and then really nailing down that purchase agreement, and some of the other agreements. So what all is kind of involved in that, in the negotiations and closing?
Yeah. So, we're at a stage now where the letter of intent is negotiated and signed. And this is typically where the lawyers really start to work on the deal on a more consistent basis. And, working through legal due diligence is coming into play. So if you're a seller, you're going to get a due diligence request list that's, very overwhelming. I get that. Yeah. I hear that all the time from our clients on the sell side that, why do they need to see every customer contract that we have, or why do they need to know about an employee that was fired, 2 years ago? This isn't relevant to our business. Well, there's a lot of money at stake here. And so everyone wants to make sure that they're at least comfortable with what's going on in the business. I mean, no business is perfect. There's warts, so to speak, with every company. Everyone's aware of that, but they just want to be knowledgeable and comfortable with that. So what happens is you're going to get a due diligence request list that's going to cover, a variety of items related to employment matters, customer contracts, governing documents for the company related to equity, capitalization structure, if there's any pending litigation or prior litigation, insurance. One thing that has come up in the last few years that has been, something that gets vetted a lot more than when I started to practice is cybersecurity. Yep. And that's just another thing with these privately held businesses that a lot of times they don't have adequate tests and controls in place for that. And so it's just making sure that if it's not in place, that the buyer is able to put that in place early on, and they're just aware of what's going on in that respect. So, So there's going to be a lot, and this is kind of running along the same timeline as working through the definitive agreement, and that is your stock purchase agreement or asset purchase agreement. And that's going to outline, the reps and warranties as a company, and the indemnification provisions, as well as, details that were carried over from the letter of intent related to payment, forms of consideration, as well as, tax obligations, non-competes, things like that.
Yep. Yeah. I know those can be pretty lengthy when you're looking at those purchase agreements and the quality of earnings report. So for people that might not be as familiar with that, and depending on what size of the business that you're selling, the buyer may or may not request that quality of earnings report, but really they're just trying to see if that EBITDA number is a true number. If that is accurate, and a lot of these deals are probably based on some sort of multiple of EBITDA. There's obviously other factors that go into it as well. When you're talking about assets and customer concentration, things like that go into the kind of the purchase price itself. But one of the things that the buyer can do is get that quality of earnings report, get that completed. So, but yeah, so the negotiations and the closing, that is, like I said, that's when you get into the purchase agreement and nail that process down. And, that can be, just kind of looking at the timeline of what you got here, maybe 4 to 6 weeks, maybe 8 weeks, for most of that as well.
Yeah. So I think that's, as a general rule, that I think tracks with our experience. Obviously sometime maybe a little bit shorter, a little bit longer, depending on a variety of factors in terms of, do you have an investment banker involved that's going to be able to help with some of this stuff, and pushing the deal across your team that's working on it. When you're involved at the earlier stages, you really have a small group of individuals that know that the business is potentially going to be acquired. Typically just the shareholders and maybe very key personnel.
Yep.
But then you start moving down and closer to closing, and more people get under the tent, so to speak, and are aware of the process and are helping out with that. And I think that's a point where, you don't early on want everyone to know that you're going through this, because, deals die all the time, or there could be something that's resolved in due diligence, and it's just something that the buyer doesn't want to take on the risk for, or market fluctuations. We're seeing that a lot with increased interest prices and rates, and so these things change. So it's a tough, it's a balancing act in terms of letting people know what's going on in the timing of when the transaction is going to take place. So
right. Yeah, there's a couple points on this sheet. So a stock purchase agreement, asset purchase agreement. So what's the difference between a stock purchase and an asset purchase? So in the interest of time, we won't cover that today. Between a stock purchase and asset purchase. Just call Aaron. He'd love to talk to you about that in his free time. He can give you a quick primer on the two differences between that. And then another thing that comes up that we notice as well that's important to the deal, net working capital. So the net working capital adjustment is another great topic. Don't have enough time to touch on that today. Again, feel free to give Aaron a call. He'd love to walk you through that.
No,
but
I don't know about that.
Yeah, that's right. So there's the timeline, and I wanted everyone to kind of get a feel for everything that goes into, once you've decided to sell, and then once you start to market it all the way to the closing, and kind of get a feel for how long that is. But now, for kind of the majority of the rest of our time, for people that are considering selling a business, or they're looking around and they're trying to determine what's best for my company, what should those people do? What are the top 3 things that people that are considering selling their business, what should they look to do?
Yeah, I think first and foremost, what I would recommend is getting your team in place. And typically your advisory team for this business, is going to be comprised of a business broker, investment banker, your wealth advisor, a tax CPA, as well as your attorney. I really think a lot of these, by definition, small businesses, they wear a lot of hats and they do a lot of things on their own, and they're not having these advisors work all the time, and they're doing a lot of things in-house. And I think for this event, you've worked extremely hard over 20, 30 years to create value in your business, and you really only get one shot at this. And my point is, you want to make sure that you get it done right, and the best way to do that is to have an experienced advisory team transition you through the process. I think kind of going through each role in the deal, an investment banker, they create a lot of value with not only purchase price, but assisting in getting you ready for the sale. I can't tell you how many times we've worked on transactions where, a client said, I thought my business was worth X, and we ended up getting, 50% more than that enterprise value. And, there's a variety of factors that go into that, but I think finding the right buyers, that's number one. Who's going to be willing to pay for that purchase price, and their opportunities to reach out and their contacts and understanding the process is going to be far greater than just what you're going to have as a business owner in terms of a group that's going to be willing to purchase your business. It's a very complicated process. I mean, there is just so much that goes into selling a business that if you've never done it before, having that advisor in place to walk you through it and understand, and prep you for these questions that you're going to be asked by the buyer group is just so crucial in order to really get that best value that you're going to be able to receive for your company.
I agree with that. Because you have to keep in mind, when you're kind of going through all the process, that timeline that we just walked through, and on top of that, you're still trying to run your business, right?
Absolutely.
So if you constantly are getting bombarded with questions and requests for information, things like that, it can get very strenuous, and that's why I think finding a business broker or investment banker that can help to shield you from a lot of that, so that you can continue to do your day to day and continue to run your business.
I 100% agree. And then as well as having a wealth advisor in place, you're working through creating, working hard to create value in this business, and you're going to have, for 99% of business owners, their most valuable asset is their business. And so, you have this liquidity event. Now you have this cash that's converted. What are you going to do with that? And more importantly, who are you going to share it with? So, I mean, it's important to know, what the plan is, as well as, working with a wealth advisor for tax planning purposes. Maybe, it comes, and this is kind of an estate planning route too, is, maybe it makes sense to set up certain, trusts or opportunities to gift equity to children for tax purposes, as well as just kind of your lifestyle on what you plan on doing, post exit, and how that's going to be financed, and what you can do, or planning on buying a house down in Florida, or what do you want to do there? So that's knowing what you can do and forecasting that with the wealth advisor, I think, is really, really important.
Yeah. And to that point, I mean, one of the things that is very difficult for people to grasp, and this is for people, especially people that are selling their business, but also just for anyone that's retiring, really, is you have to go through a complete mindset shift. Right. A lot of the people that we know, and a lot of people across the city are very conservative with their money, and they're savers, and they're so used to, hey, here's my income, my paycheck's coming in on a steady basis. That's great. I'm used to saving. They get very good at saving and plowing money back into their company, plowing money into their retirement accounts or brokerage accounts. That once that shift happens, and now they've got this big pile of money sitting there, and they're out of the saving phase of their life. They're out of that accumulation phase. And now they're in the withdrawal phase, right? How do you go about what's the best way to spend that money, and to spend that money in a tax efficient manner? Very important thing to consider when you're in the process of considering selling your business.
Yes, absolutely. And then also, a tax CPA, I think a lot of times our transaction structures and how we as attorneys draft documents is all, for the most part, there's tax ramifications, and it's driven by tax decisions. So having a CPA that's going to be able to help guide you and understand, the ramifications on doing an asset sale versus a stock sale, or when we're working through the representations and warranties of the purchase agreement, helping out with that piece of the deal, as well as if there's going to be, what's called rollover equity, where part of your purchase price is going to be in equity of the buyer, or an affiliate thereof, to make sure that transaction is tax deferred versus recognizing income on that piece of equity. That's really important.
Right.
As well as, just doing an analysis on what you're walking away with. I mean, even in, a favorable tax rate environment that we're in, it's still a significant chunk of your walkaway monies. You're going to be paying taxes on that, not only at the state level, at the federal level, but state and local level as well.
Yep.
And then lastly, attorney, which is where, I come in, is, really papering up the transaction, but as well, helping out with negotiating this and really, with the investment bankers, providing kind of a holistic view on everything going on and making sure that everything's moving forward in an efficient manner, negotiating on your behalf. That's something that's along with the investment bankers that we do is, it's tough sometimes, especially if you're going to be working with the company after the transaction closes, is to have those negotiations directly with the buyer or the new owner of the company, and maybe a board of directors that you're going to be reporting to. So having that layer is really important, as well as just general experience on working through these matters, on what's common and what's not, and helping with representations and warranties, disclosure schedules, things like that, ancillary docs, employment agreements, because it's really important. And it's purchase price is one thing, but it's not the only thing when it comes to these deals, and we see that time and time again, that there's just a lot to a transaction and the outcomes there too.
Well, great. So step number one is obviously to assemble your team, and you listed out the different team members and people that that they should be considering and sitting down and meeting with and going over their goals with. So what would be step number two here for second thing I'd look to do?
I would say just get an understanding, a holistic viewpoint on what you want from this transaction. Is it just going to be you go to your investment banker, or you market the business and say, I want the top dollar that anyone's going to pay me, and I don't care about anything else? Well, 99 times out of 100, that's really not the case. People care about how they're going to get paid, whether that's going to be some form of rollover equity, as we discussed, or a seller note, seller financing, as well as really their legacy. A lot of these people that are business owners have run these companies for 20, 30 years. I mean, they truly believe these employees, some of them are actually family members, but they feel as if a lot of them are family members with how long they've worked with them and the amount of hours they put in together. So they want to make sure that they're taken care of. And then, along that line, we kind of talked about, do you want to maintain part of the equity in this business? Do you plan on staying involved as a CEO? If it's a private equity group that's going to come in and buy this, they may require that take place, because they may have a management team that they intend to put in place, but a lot of times they anticipate that the current management team is going to stay on, and what they want is for you to have some skin in the game, where you take some chips off the table, but you also are keeping equity in that business in order to increase the value. And, I've worked through transactions where this is, worked out phenomenal. And, sometimes the second bite of the apple, so to speak, is almost as much as that first sale, which is unbelievable to think, because of the ownership being smaller, but the value has just increased so much with the new, private equity group assisting. But I've also seen it happen the other way, where, you roll over a lot of equity and things don't work out. And, the valuation goes almost, down to zero, or it's less than the value that you rolled.
Yeah.
So that's, another component of this.
Yeah, that's an enticing opportunity. And really it goes to show you how much faith you still have in the business and how much faith you have in the buyers as well. I get it. Some people, if they've been in that business for 30 years and they're done, right? They're looking to get out. They want to get as much out as they can, and they don't want to step foot in that office again. Whereas, yeah, like you said, maybe the second bite is even bigger, and somebody with a fresh set of eyes on the business and ideas that grow can expand it even more. So yeah, that seems pretty interesting. That's something that, if I'm advising a seller around, if they can get, a small piece of equity or roll over some equity, seems like it'd be a great opportunity for them.
Yeah. And I think that kind of goes back to the initial phase in selecting a buyer. If that is something that you have in mind, if you plan on rolling this equity, you want to make sure that it's a good cultural fit. You want to make sure that, the value is going to increase. And, a lot of times, company culture is something that gets stressed all the time in business. And there's a reason for that. And so to make sure that this group is going to have synergies around what's currently in place is really, really important, especially if you're going to be rolling that equity, because not only financially, but with the sense of staying on in that business, just from a lifestyle standpoint and your legacy, you want to make sure that maintains there.
Yeah.
So.
Right. Well, cool. Yeah. So lastly, the third thing that people should look to consider, and if they're looking to consider selling their business.
Yeah, and I think it's just getting ready for this process. I recently read a report from the National Center for Middle Market, and it stated that about 50% of companies that are going through some type of transition or transaction process, they start preparing for this at least 1 to 2 years prior to the transaction closing. And so this isn't something that is, you can get through in 90 days or a quarter, even if you have an unsolicited offer. I really think there's a lot of preparation that can go into creating the best value for your business. And I know investment bankers, they harp on this all the time, and it's very true. If they have more time to work with you in order to kind of tease out the skeleton, so to speak, or answer questions that they know are going to come from a buyer group, that really helps with maximizing value of your company. Right. I really think, and then in addition to that, there's always a saying in M&A that time kills all deals. And so if someone comes to you and you're working through a process, and then they find out that you don't, for example, have reviewed financial statements or audited financial statements, and they ask you to go do that, well, there's things that come up in the interim that, whether, and we talked about before, just the economic uncertainties that happen, interest rates, the buyer may be transitioning out of your market. So, things happen in the interim which can really kill a deal. And so being ready prior to that is really important. And then, as well as just kind of keeping sure, and this is where we come in a lot, is making sure that corporate matters are organized. Governance is kept up to date. There's a lot of times where we'll get involved with a company, and the last shareholder meeting they had was 5 years ago, and so it's making sure that the records are kept up to date over time. Capitalization table is clean, where there isn't someone that you didn't properly document some type of stock option for, or someone left the company years ago, but they still had equity and no one's really talked to them in a few years. And now you got to come back and get their consent to approve the deal. These things happen, and it's better to have them addressed prior to engaging with a prospective buyer going through the process, because it's going to need to be resolved eventually. So why not do it in advance? Because it really helps through the transaction process. Mm-hmm. As well as, some things that, this gets fleshed out in due diligence, but some things to keep in mind are making sure that, you have employees, sales reps or really anyone with confidentiality agreements or non-competes and non-solicitations. Even if you're not a technology company, it's really important to understand that there is value in your confidential information for your business, and to make sure that that is all properly documented, that you own that.
Right.
As well as just organizing, we talked about this before with due diligence in the data room. You're going to have to disclose these contracts, your vendor contracts, your customer contracts, your employment agreements, pending litigation, all that stuff. So being really organized up front, I think, is huge, because if you're disorganized, this takes you forever. And John, you already harped on it. You're still running your business. And so it's very difficult for you to take, an entire afternoon off to go organize, or even longer, to go organize all this documentation that a prospective buyer is going to want to see.
Right.
So making sure that that's just all in place prior to going through the process is going to be very beneficial to do so.
Yeah. Well, great. So, before we wrap up, and I appreciate you, providing all of this information. Is there any last pieces of advice that you would share, or any last things that you would say for anyone looking to sell their business?
Yeah, I mean, I think it's a don't go at it alone. I think we stress that enough, that having a team in place is important. I think being organized with the whole process is really important. And I brought this up before, but I'll harp on it again. Is just with a seller, and the importance of at the letter of intent stage being able to negotiate and create favorable terms there is really, really important. And it's tough sometimes when we get engaged and, oh, by the way, here's the signed letter of intent to look at when the purchase agreement rolls through, and you look at it and say, this isn't addressed, or we could have got this, and what's coming in the purchase agreement from the buyer is it's going to be definitely terms that are more favorable for them. And so it's an uphill battle to fight on that. So I think, it's really important to understand where your strengths are in the timeline of a deal. And that's definitely prior to the letter of intent stage.
Yeah. Awesome. Well, great. So Aaron, I appreciate you taking the time to spend with us today. I'll have, your contact information here, and make sure you reach out and connect with Aaron on LinkedIn as well. He does a great job, and Aaron, I appreciate all the help that you've given me and our business partners. So appreciate that, and thanks for joining us today. And for those that are listening and watching, make sure you go connect with Aaron on LinkedIn. Check out the Kohnen Patton website. Get all the information there.
Great. Thanks, John.
Yep.